Welcome, everybody. I'm Matt Crowley, COO at FMA. With me today is Ronald Chapman, who is the founder of Chapman Law Group, a Troy, Michigan-based law firm dedicated to health law and representation of health professionals, healthcare providers and facilities, correctional healthcare providers, and professional liability insurers. Summer McKeivier, a shareholder with Chapman Law Group based in Los Angeles, is an experienced federal trial healthcare fraud defense attorney representing clients nationwide in the areas of federal criminal defense, healthcare fraud and abuse, governmental investigations, and DEA matters. And with that, I will turn it over to you all.
Good afternoon, everyone. So Chapman Law Group was founded back in 1985. It specializes in representing healthcare providers. Currently, I think we have 19 attorneys in 3 states. We have offices in Michigan, Sarasota, Miami, Florida, LA, and a small operation in Nashville, Tennessee. We're divided into 4 divisions. One is the white collar division. We have a regulatory division that deals with all matters licensing, certifications, DEA registrations, all of those types of things. A compliance division that deals with all compliance matters with third-party payers, government payers, all of those related type issues. And then we have a civil litigation division that deals with the civil aspects, things like Qui Tams, forfeitures, those types of things. Let me sort of give them to you in the order in which we're going to talk about them because they kind of go together. So one of the first areas we're going to talk about is audits. Audits tend to start a lot of problems, and we'll get in more detail with them. We'll talk about false claims, those related issues, and how they could relate to your practice of medicine. We'll also talk about Qui Tam issues, which often flow from some of these audits and other things. We'll talk about civil investigative demands, which is a tool used by the government. We'll get into that a little bit more detail. And then we'll talk some about kickbacks, how those can relate to the practice of medicine and what kind of trouble people can get into. And then we'll talk specifically about Florida, an area called fee splitting, which is sort of like a kickback, but it's not a kickback, and it applies to all things Florida. So with that, let me start off with audits, since that's more of the civil, and then Summer and I will exchange back and forth and talk about those areas. An audit is basically when the government or a third-party payer, it could be Blue Cross Blue Shield, Aetna, United Healthcare, any of these entities, decide that they want to look further into your billing practices. Specifically, when the government does this, there's a couple levels of audits. They generally start with you receiving a letter, sometimes a pre-phone call that says, hey, we're going to want to look at some records, or you receive a letter that says, hey, would you send us 30 files or 20 files or whatever those are. And there's a couple types of audits. I'll tell you the ones you should be very concerned about, and then the ones that actually are there to benefit you. There are audits that are called ZPIC and UPIC, Zone Program Integrity Audits and Uniform Integrity Audits. These are fraud-related audits. They're looking for fraud. So whenever you get one of those audits, for sure, you need to talk to counsel. Don't try to engage in that particular audit by yourself. And then there are things that are called RAC audits, recovery audits. Those are specifically looking to recover money. There's already been a determination of some kind of payer activity that they believe should result in money paid back to the government. So when you receive a ZPIC, UPIC, or a RAC audit, those are really important. Those can trigger a whole bunch of other things that we're going to talk about, and Summer's going to talk about as well. And then there are audits called CERT audits. You receive them all the time. They're post-payment audits where they're basically looking at your payments and your records that you've submitted, your documentation of those payments post-payment. Oftentimes those result in educational tools. And then you have something that's really considered a friendly audit called a TPE audit. It's a targeted probe and education audit. The purpose of those audits are basically to educate you in a particular area so that you don't run into problems. All of these audits start the same way. You receive a letter and says, hey, we want to see some records. You put those records together and they go off to the medical administrative contractor, the MAC, who wants to look at those records. And that's where the problem starts. The problem starts with preparing the records that are sent. We're dealing with a major audit right now of a wound care specialist. The first thing we did was ask them to send us the records first before they were sent off to, in this case, First Coast. And what we found were a number of problems. They were using the wrong billing codes. They were billing for surgical procedures that weren't surgical procedures. And in a sense, they're going to have some serious problems. So we identified those problems up front. We were able then to attach to each claim an explanation because there was a further story as to why things were the way they were, not an addendum to the records, just an explanation. And we were able to give them some corrective action plans, and we're creating a more robust corrective action plan for them to immediately correct these things so that when things happen, and if this kind of blows up, they will already have a corrective action plan in place. So what'll happen with that audit is they will send back their first determination of what they believe are incorrect billing records. The documentation doesn't support whatever the CPT, the ICD-10 codes might be, and we'll have an opportunity to appeal that. Then there'll be a redetermination, and depending upon what the results of that are, it escalates on up. There are 5 levels of appeals. After the redetermination, if there is a determination that money is due, then the letters start coming in that says, hey, repay us 10,000, 100,000, a million, 2 million, whatever the figures are. And sometimes those come in a series. In each of those levels, you have opportunities to appeal. But the big thing I want to talk about with audits is it starts when you first receive the audit. You need to give the attorney the best opportunity to resolve the problem. Many people say, well, I'll just use my billing company and they'll respond. Understand this, the billing company, if there are incorrect documentation, incorrect codes being used, incorrect modifiers being used, remember, it's the billing company that allowed that stuff through in the first place. So they're probably not the best person to prepare and to defend against the initial audits. So it's good to retain an attorney. That sometimes is hard. I talk to a lot of clients initially and they want to do it themselves, irrespective of my opinion, they shouldn't. And then they get a bad result and then they call us. And sometimes the things that they've said, the things that they've done are things now that the attorney has to live with. And that becomes a problem. And out of these audits, stuff happens. I mean, there are things that are found which can trigger some other things. And that's kind of a segue into false claims. And I'll kind of kick it over to Summer, and she can talk to you a little bit about false claims.
So just picking up where Ron left off, what I would start with is to say, you need to know the difference between a biller and a coder. I always advocate to hire not a billing company, but a coding company. And the difference between those two are coders actually go to school, go to classes, and they get a certificate. They're called certified professional coders. They're the kinds of individuals who can look at your medical records and see what you've actually done, and from the medical records, tell you what CPT codes or enter what CPT codes apply to not only the services you've provided or the supplies you've used, but to make sure that that documentation meets the CPT code. Billers, on the other hand, are just really data input. And most billers, they do not have a certified professional coding certificate, then that's not where you want to go. My advice is to always have a certified professional coder. Do not try to code yourself. There's no way to be a doctor and keep up with all the codes with the different insurers, and they consistently change. Not only that, we don't just have one set. There are subsets that apply to local coverage determinations, which can be just applicable to certain areas, meaning geographical areas. So my advice is always that you want to start out when you have a clinic or if you own the actual practice, you want to hire a company to do your billing that has certified professional coders, and then you allow them access to your records so that they can not only get it correct, but make sure your documentation is correct. And also they can get you the most money because you may miss something. It's very important to get someone who's qualified like that and not someone who just says, oh, I've been billing forever. A lot of people have worked in hospitals and just put the data in. That's not the same thing as a coder. Start with a coder because that is something we can rely on later if there is an error, because you've done everything you can to hire the professional to help you do that. So Ron said that after the audits, what can come, that's kind of how the trickle down into false claims, or what I do, healthcare fraud. The difference between those two are basically one is civil, and they're just going to want money and penalties back. And of course, the other one is there's possibility of not only do they want money back, but they want potential punishment in custody. So clearly everyone wants to stick with a false claim, even though that can go into treble damages, meaning whatever you may have submitted that was fraudulent or false, if it was $100, the government has the ability to receive $300 back on that. So it triples the amount of damages, or it can. Ron is absolutely correct. You never want to do it yourself because it's better to explain ahead of time where an error or where something may have happened than to just send the records and have them respond. And then you're like, oh, but this is what this was, this is what that was. It's also better to fall on your sword and say, we recognize this error when we were preparing the records, and we now are putting in a compliance officer or a corrective action plan. Always better to go in with the truth rather than just hoping for the best with your records. Which also leads me to the other thing. Besides a certified professional coder, medical documentation is the number one thing. I cannot stress this enough. Yes, the way you practice medicine is important, but documenting what you're doing and maybe why you're doing it. I'll just give a small example. If you are a physician that prescribes controlled substances and you change the prescription of one of your patients to a stronger or even a lower dosage, note in your records why that decision is made. Not just that one day they got Oxy 10 and the next visit they got 20. What happened? What did they say? What was not working or what was working? So documentation is where everything starts and ends. We can defend anything as long as there's documentation. Because at that point, it's just a matter of, let's argue medicine. We can't go back and say, oh, he remembers what happened or she remembers what happened in the room that day with that patient. That may be the case. I'm sure you do, you know your patients, but the government is not going to trust your word in the back end. So you really want to have that written down contemporaneously. I cannot stress enough that keeping your records is very important. So what all of those audits that Ron just explained, what they can lead to is the government or the payer deciding that there was some kind of fraudulent or false submission for reimbursement. We hope it's just a payback, but they can go further. In the civil arena, False Claims Act will still be going through U.S. attorneys' offices in their civil division, and we'll be negotiating the payback. And then if they believe that you did the false billing or the fraudulent submissions intentionally to increase reimbursement, that can ultimately go all the way to what would be a criminal indictment. There's not a lot of difference between a false claim and a criminal indictment as far as what do they need to prove that. It's just kind of a threshold that the government decides. Is this egregious enough that we need to punish someone? Or do we need to just say, hey, slap on the wrist, pay us the money back, and then, but either one is going to result in the possibility of you being excluded from being able to bill a healthcare benefit program, which means you can't accept Medicare or Medicaid. And from there, private insurances will follow suit, and then you're really up a creek without a paddle when you cannot continue to work without people actually just paying cash. And so those are how everything kind of trickles down from an audit. They get the information and then they just decide what's the degree of problems we have here or the degree of intent that we believe this physician submitted these claims for reimbursement. But they mirror each other, just one's a monetary punishment and the other one can have time in custody. There's also other crimes, not just healthcare fraud. There's false claims, false statements related to healthcare matters. That's also another criminal code that they use. But all of it basically comes down to the information that was put into that claim that was submitted for reimbursement.
A couple other matters with respect to false claims that if you're ever involved in that or just knowledge to stay out of it, there are two ways to submit a bill. You could submit a bill to CMS using a 1500, which is paper form, or you could use the UB04, which is electronic form. In either case, the physician, that's the billing physician, certifies that the bill that's being submitted is true and accurate. That means that the physician has the appropriate credentials. The physician has a PTAN number. The physician has their MPI number. The physician is able to bill Medicare, TRICARE, Blue Cross Blue Shield, whatever it might be. And that's really important because one of the areas that people get into trouble is the use of mid-level providers, PAs, nurse practitioners, those types of things. And so there are certain ways to use their services to maximize reimbursement. There are certain ways not to get too deep in the woods, but one of the areas that causes many problems with physician is the incident to provision. So going with the certification, the physician sees a patient, uses a nurse practitioner or someone to provide those services, and then bills the service with the nurse practitioner as being the provider and the physician being the one that reimbursement is going to. That's permissible. as long as the physician did the initial treatment plan, and then the nurse practitioner is doing the follow-up, the treatment care, and implementing the plan. The reverse, though, if the nurse practitioner sees the patient, creates a plan, implements that plan, it's permissible for them to do that, but it's not permissible under Incident 2 for the physician to be reimbursed at the physician rate. They'll be reimbursed at the lower rate of 85%. Why do I go into all that? It's kind of deep in the woods. One, because it gets physicians in trouble on a regular basis. The other is using the wrong modifiers. So following up on what Summer said, when you have your billing company or preferred your coders, professional coders that are coding things, when they code to use a specific modifier, let's say modifier 25 that allows 2 services to be billed for the same treatment, you're the one that's signing on that dotted line, certifying that that's the appropriate code. When they use a particular CPT code or ICD-10, you're certifying that that's accurate. Now, the problem with that is this: you probably don't know what the right codes are. You probably don't know if the modifier is correct or not correct, and you're relying on the billing company, the coders that are coding it. So make sure, following up what Summer said, that you know what your coders are coding, and you take some time to understand before things go out. Now, the other problem is electronic billing goes out automatically without you ever seeing it. So you have to have processes in place. You have to have a compliance plan in place with checks and balances to ensure these are going out correct. Compliance plans, we haven't mentioned that, but they can get you out of a lot of trouble. If you have a detailed compliance plan and you're implementing that, if you have a plan in place, you have a process of auditing it, you have a process of catching irregularities, you request in changing the irregularities, you're doing the right thing. So that's the thing with false claims. So there's 2 types of false claims. One is when you present the bill. So if you present a bill that's not accurate and you signed it, it's a false claim and you got reimbursement for it. The other is using some type of instrument. In this case, it's a bill. So those 2 go hand in hand, and submitting a false statement. And like Summer said, false claims can just be an economic thing. Most of the things that I deal with, because I'm not a criminal attorney, is money. The government wants 10,000, 100,000, a million, 10 million, whatever the amount is, they want back. And here's an interesting thing that most people don't put into place. They kind of recognize there's going to be a fine, but those fines are 3 times the amount billed, plus depending between $13,000 and $23,000 per line item. You could have 10 line items for $1 each, that's $30. Times 10 times 23,000, that's 230. So now your bill to the government is $260,000. That's the extreme. The government always negotiates down from that, and that's one of the reasons why you want to have an attorney, because we can bring that down maybe to just $30 or whatever the case might be.
When Ron began with the Incident 2, one of the things to understand is if you are employing mid-levels, nurse practitioners or physician's assistants, and Ron's correct, if you're going to be using the Incident 2, you have to have seen the patient, created the plan of care, and then this may be the provider that sees them on visits unless you're needed. But in order to bill for a mid-level provider under the Incident 2 rules, which allow them to be billed at the physician fee reimbursement, you must be in the office, the physical location, in order to bill at the physician rate for a mid-level provider. Otherwise, that service needs to be billed. The mid-level provider needs to have their own PTAN. They need to be credentialed with the insurance, and it needs to be billed as they are the rendering provider. Now, yes, you're going to get an 85% reimbursement from what you would get at the physician level, but that's where a lot of people get in trouble is they think, hey, I have these mid-levels, I can start to wing down my practice or not be there every day. That is not allowed. You cannot be reimbursed at the full physician rate if you are not in the office.
These kinds of things have real consequences. And don't think I will never get caught, which is a rare thing, because most of the things I deal with, and some are maybe a little different, but I don't think so. Many of my physicians don't know they're doing it. When I talked to them initially, they said, this can't be because I practice good medicine. My patients love me. I've never been sued for malpractice. I tell them all of that's good, but the government doesn't care. What the government cares is you incorrectly billed them for X amount of money and they want it back.
Don't rely on the government to be the one that tells you either. A lot of people are like, well, if I was doing something wrong, why didn't they just send me a letter and then I would have corrected it? That's not how it works. They're not there to police you until they're there to police you. They're not watching everything, but once they figure it out, they will, then you're already in it. That's why it's important to always get a lawyer ahead of time. And I think, like Ron said, a compliance. If you're going to have a practice, have someone come in and audit and see if you're doing everything right. It's so much cheaper to do that ahead of time than on the back end where the damages become triple. I always think spend it up front, because if you're doing everything the way a compliance attorney has told you, you should be okay, and with check-ins here and there when things change. There's also self-disclosure. If a compliance attorney came in and found that you've been billing this the same way for 10 years, but it's been incorrect, then we can self-disclose to the government. While that does result in you having to pay some money back, what it doesn't do is it doesn't have the collateral effects that a false claim or an indictment can have, and that is the exclusion from Medicare and all of the ways in which you can really go out of business other than money.
One of the things that many providers say is it's too expensive to hire a lawyer, too expensive to have a compliance plan, all of that. And it is too expensive until you get the fee for a criminal attorney or for some serious audit. But one of the things that we do is, and what many people participate in, is a fractional plan where basically you hire an attorney for a discounted rate, 50 hours of service in a given year, or let's say 100 hours of service. So it's really efficient for you just to call that attorney and say, hey, I found this, I found that, what can we do? And the attorney many times can just answer things over the phone or over the internet, give you a written response, and that kind of reduces your costs, but saves you in the long run. Now, one of the onerous things that happens, you got the government coming after you, but you also have every disgruntled employee, citizens, people that think they know better than you and how to bill, and those are called Qui Tams. A Qui Tam lawsuit is a lawsuit where an individual, a citizen, private citizen, believes that they have found fraud. So what happens is an individual determines that they have some kind of action, they hire an attorney, the attorney usually takes it on a contingent fee, and they draft a complaint along with something called a self-disclosure, which is a detail of everything they believe happened and why it's a false claim, why it's a kickback, why it was healthcare fraud, why it was whatever it was. And then that's filed in federal court, and it's filed under seal, so nobody knows it's filed. The government then inspects, investigates, and begins to prosecute that. So I'll switch that over to Summer, because if that happens, bad stuff might be happening.
So usually a whistleblower or a Qui Tam is going to be some old employee or sometimes a current employee, because they can make a lot of money themselves off of these things. And they have information, inside information, that maybe the government wouldn't have been able to find or couldn't find publicly. And they hire the lawyer, they say, hey, they've been billing toenail clippings as massive avulsions, where you take the whole toenail off. Clearly one reimburses higher than the other. And they've been doing that ever since I've been working there for the last 5 years. So once that's filed under seal, the government has to look into it. They begin their own investigation to say, okay, is this correct? And they pull the claims and things of that nature. But the way in which they do that investigation is they will issue a civil investigative demand letter to you. It's just like a subpoena, but it basically says, hey, we're looking into this, false claims, kickbacks, whatever, and we are requesting all these records. They're basically asking you to provide them what can prove whether you did or did not do what the whistleblower says. And once we get there, the government has to make a determination. And that is whether or not they're going to intervene in the Qui Tam. That means the government says, thank you, whistleblower. Sit back over there and wait for your money. We're going to take over for now, and we're going to go and get this doctor. We're going to sue him or whatever. And usually those are negotiated during the process of the CID, and you don't actually take it to court because the damages can be massive. Because ultimately, again, the penalties are triple. Whatever you may have overbilled or whatever, let's say $1 million, the government has the ability to get $3 million. And if you go to trial, they will get that $3 million. Whereas in a negotiation, they negotiate to like a 1.5 or somewhere in there on an ability to pay basis. But you also have to pay the lawyer for the Qui Tam, the whistleblower, the relator is what they're called. So you have to pay all of that attorney's fees as well. And those get high, which is why the relator or the whistleblower actually is entitled to a percentage of whatever amount of money the government recovers. So that's why these attorneys will take these Qui Tams on contingency, because the dollar signs are at the end. Even if you negotiate a settlement, they still get a percentage of that, and their lawyers still get the fees, which are also your responsibility under the law.
The other thing to talk about, some of the practical or pragmatic things to discuss here, one of them is if the government does claim that you owe them money back through civil investigative demand, through just an audit, through whatever. Now it becomes kind of pragmatic. Should you pay them back or should you fight? And we often have to explain, look, the costs of fighting can oftentimes far exceed the cost of initially resolving it. The problem is sometimes getting over the physician acknowledging that, hey, I didn't do anything wrong, but I might as well just pay this because it's the most cost-effective thing. And that's part of the discussion we have with clients when they call up and say, hey, the government is after $100,000. We say, well, you can hire us to negotiate a lower settlement, which is good, and then pay it. Or you can pay us $100,000 to fight it so that you don't have to pay $100,000. And we have those discussions because our goal is to have clients for life, not to get as much as we can for each little claim that comes in. So that's one thing. Another thing to be aware of, Summer mentioned, sometimes these lawsuits come from your employees, your prior employees. So I had an interesting case. This goes back years ago, probably back to the 90s. So I represented 5 people that were swindled by their financial planner. In the end, I wasn't able to really prove. I knew it and I knew what I needed, but I couldn't prove it. So I told my clients, look, we can't prove this. There's not much further we can go. And about 6 months after that, my secretary said, Harriet's on the line and demands to talk to you. Who's Harriet? I don't know any Harriet. She called up and she said, the SOB fired. And I said, fired you? She said, yeah, you remember I worked for this financial planner and you were investigating. I have everything you need. About 6 months later, we settled the claim. So be careful sometimes of employees that often leave disgruntled, or maybe that you terminate and you don't do a proper assessment, but they don't know what they're going to do. Sometimes giving them a severance pay and having them sign a non-disclosure agreement, a severance package agreement is a good thing to do. So there's a lot of ways that healthcare providers can get in trouble. Another way that we want to talk about is a thing called a kickback. Well, let me turn it over to Summer and she can talk a little bit about kickbacks, which many clients, particularly foreign clients, don't understand this because this is the way they do business in a lot of foreign countries, but it's not the way we do business in the United States and get you in trouble.
So a kickback is basically any kind of remuneration money in return for a referral of a patient for which a government healthcare benefit program will be billed for those services. And what it is that, you know, there's a lot of competition out there and people are like, well, I need to market my business. Well, marketing is absolutely legal. This is a capital society. You can advertise your business. You can go to physician's office and say, hey, if you have patients that need to go on home health care, here's a flyer, here's the name of our company. We'd love to take care of them. This is our area. But what happens is a lot of times they will hire these marketers, recruiters, and they will pay them per patient that gets referred and accepted as a home health care patient. And that is illegal. That is a kickback. Because the problem with that is that they're out there soliciting patients directly sometimes. And they may be giving those patients food, liquor. I mean, it just depends on whatever that person's thing is. And so the patient doesn't really need home health care. The way that it is kind of marketed to them is concierge doctoring. We're going to send you your nurse. We're going to send you your doctor. They're going to come check you out and they're going to get you your meds and whatever. You know, there are requirements for a patient to qualify for home health care. There are requirements for a patient to be put on hospice. And that really needs to come from their primary care physician, not from some community liaison that goes out to different areas of their neighborhood and says, Ms. Smith, I know it's hard for you to get yourself to the doctor. I can sign you up for this home health care company. And then the home health care company sends a physician to basically certify them for home health care. You can't pay the doctors either. Actually, you should never pay a doctor for referring a patient ever at all. Now, it's a little different if you want to send people out there to market and advertise, but you really need to pay them a fair market value for their services, whether or not they actually get a patient for you or whether or not that patient is ultimately signed up and eligible for home health care or hospice. And so that's really where the anti-kickback comes in. But what you need to be wary of, and what any good attorney needs to be wary of, is that can also go criminal. I mean, as we said with false claims, it is a very thin line between a civil false claim and a criminal healthcare fraud prosecution, because the facts or the elements are pretty much the same. It just depends on whether or not the government thinks they can prove that you intentionally did this. Like you knew it and you did it to defraud and increase your reimbursement. And you don't want to just start throwing it all out there and negotiating a resolution on a civil case until you can find out, is there going to be a criminal action? Can we settle this together? Should I stop speaking because I have a Fifth Amendment right? So because those things are filed under seal, any good healthcare attorney is going to say, wait a minute, where's this coming from? How did this begin? That's why, again, we say do not receive an audit letter, do not receive a civil investigative demand letter, which will come from the U.S. Attorney's Office or the DEA, and sometimes they send out similar administrative subpoenas. Do not trust that, oh, I'm practicing good medicine, I know I'm doing it right, like Ron said. I'm sure you think that, most people do, because practicing medicine is a job in and of itself. It's an all day, that's all you think about. Having to know these minutiae, these small administrative details, especially how often they change, is impossible for one person to know and keep up with.
If we have time, there's one issue to bring up with the anti-kickback statute, and that is there are safe harbors. The safe harbor is a construct that the government's put together, and if you place yourself within that construct, then there can be no violation, or at least you'll be protected if there's a violation. And give you an example. If you hire somebody by a 1099 and you have them go out and recruit patients for you, that's a violation. If the person, what's called a personal services agreement, and the compensation is structured, the agreement's for more than a year, there's other kinds of requirements for that, then you can go ahead and do those types of things.
All right. Well, thank you all very much. This has been great. Like I said, I think we've thought up a few new topics for other webinars we could do in the future here. So that said, Summer and Ronald, thank you all very much for coming on today. This has been great. I think we could have gone probably another hour pretty easily. But thank you again, and it's been great, and I hope to see you all again soon.
Thanks for having us.
Thank you so much for the opportunity.